and maybe to put some boundaries around all of that, there's a serious problem that drives the uncertainty problem. And the serious problem that every patent lawyer knows, whether representing plaintiff or defendant, is that nobody knows what's really, what skin there really is in the game until you've got a rich understanding of the infringement and a rich understanding of the prior art. You need a third thing, but that's always known early in the case, which is a rich understanding of the record before the office so you can do a Section 112 analysis. But the reality is you've got several moving pieces. The claim, that sentence at the end of the patent, and whatever difficulty there is imposed by the rules of claim interpretation, we'd all be in favor of doing it better rather than worse. But we still have to do it. It's going to be hard. So you've got that claim. You then have to map it on to the disclosure as filed, the art as discovered, and the infringement as discovered. And it takes thousands and thousands of hours of attorney time to discover the art and to discover the infringement. And so just socially, we'd all like it to be done in a patent office at $10,000 or $100,000 or in a quick, fast opposition proceeding. But we all know that that amount of money won't finance that amount of due factual investigation. If we substitute it with administrative deference, flexible kind of just trust me, I'll tell you what I think the art meant, or just trust me, I'll interpret it and give it to me. My fear is unless I'm constrained, I, the decision maker, am constrained by either a very, very tiny degree of freedom, in which case I as a so-called pro-property guy would be happy with any answer as long as it's constrained, or constrained to a factual record rather than a politically influenceable record, then I'd be happy with the outcome. But my fear is that most of the changes we've been making into the system have ignored those very, very real costs. You've got to spend thousands of hours of attorney time to find out about infringement and to find out about the prior art. So they've been ignoring that cost, and they've been ignoring the cost of political gerrymandering by empowering an individual to just say what she feels like saying in the moment. So we should take seriously all the problems with patents, but we should also take serious these problems of figuring out what really is the data we collectively need to make a good decision about the patent, and then what are some mechanisms for doing that through a judicial system that will, on average, not be too delayed and too expensive, sure, but also, on average, not be too subject to political whim.
Okay, we've got time for one more short question and answer exchange. Sir?
I'm Brian Bishop from the Ocean State Policy Research Institute. I wanted to ask, actually, and to challenge Dan's fundamental concept that wasn't really challenged on the panel, because in a sense about economics, that there is no such thing as intellectual property. I mean, I'm wondering, in looking for your fair result, I don't think anybody can have seen, for instance, Flash of Genius and recognized to an extent that a patent is not solely about who has access to it, but also about the person who creates it. And so I'm asking you, if you can't see that what you're really asking for is intellectual kilo. And I think we've just had the evidence that kilo wasn't the way to go with real property, and I think it makes clear how closely the two concepts are aligned.
I don't think I said I disputed the concept of patents and copyrights. What I said is the term intellectual property to describe these categories of different things, I have a disagreement with the appropriateness of that. Look, there's no one in this room who believes stronger than me that patentees should get every single dollar they deserve for the investment they've made, the risks they undertook, and the innovation they provided to society. No one. I will, that is something I firmly believe in. At the same time, I don't believe patentees should get more than they deserve, and I think the point of our patent system is to advance the level of technology available to the public. That is more important than the individual reward, which is an intermediate step to provide that advance. And I understand that I have intellectual disagreements with many people on that topic.
Yeah, no, look, I think the biggest mistake in that argument is to assume that every time you talk about the effect of public from advancement, the idea is it's going to be a negative rather than a positive effect. My view about it is that most of these patent situations increase options for the public rather than reduce them, and so I think the danger that Dan has is he's got the public vector going in the wrong direction. He treats it as a minus when in fact it's a public technology is a positive-sum game, and when you start treating it as a zero-sum game or as a negative-sum game, you're always going to make mistakes. And the property analogies are what keep you going in the positive transaction. Mutuals change from great.
That's only if you have correct actors in the system. When you make too many errors, then you have negative externalities from the errors in the system, so you can't infringe a patent on prior art that was something that everybody could have done previously. So the system worked perfectly, I'd agree with you, but it doesn't.
Look, it doesn't, but
and that's the negative externalities.
No, the negative externalities, people misapply obviousness, but the bigger negative externality is to think that the way you handle that thing is to blow the whole system up. And you may think yourself to be the best friend of property, but if you start saying that you know the line between excessive and legitimate properties, you're just essentially the wrong kind of regulator, and I want nothing to do with the kinds of things that you want to do to us.
All right. Thank you. Richard will have to have the last word, as he often does.
It is correct.